Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Thank you for tuning in to the October 21 term of SCOTUScast. I'm your host, Nick Garfinkel, on behalf of the Faculty Division of the Federalist Society. On November 8th, the court heard argument in Federal Bureau of Investigation versus Fazaga, a case which concerned the interaction between the Foreign Intelligence Surveillance Act and the state secrets privilege. Joining today to discuss this case in great detail is Sohan Dasgupta, of counsel at Schaerr Jaffe. Dr. Dasgupta has served as the Deputy General Counsel of the U.S. Department of Homeland Security, Special Counsel of the U.S. Department of Education, and is adjunct faculty at George Mason's Antonin Scalia Law School.
The question that the Supreme Court has agreed to resolve is whether Section 1806F of the Foreign Intelligence Surveillance Act of 1978, or FISA, displaces the state secrets privilege and authorizes a district court to resolve in camera and ex parte the merits of a lawsuit challenging the lawfulness of government surveillance by considering the privileged evidence. Oral arguments were heard on November 8, 2021. A decision from the Supreme Court remains pending. Now, FISA regulates the government's collection of electronic surveillance for foreign intelligence purposes. And Section 1806 of Title 50, which is the pertinent FISA provision in this case, established procedures for the lawful electronic surveillance of foreign powers and their agents. FISA, in effect, creates a system for in-camera, ex parte, judicial review of electronic surveillance evidence when the government tries to use such evidence or a surveilled party tries to suppress it. Now, first, let us discuss FISA. FISA sets forth this definition of electronic surveillance. It is the acquisition of wire, radio, or other communications within the United States in certain respects. When the federal government conducts electronic surveillance through the installation or use of an electronic, mechanical, or other surveillance device in the United States in order to acquire information other than from a wire or radio communication, where a person has a reasonable expectation of privacy and a warrant would be required for law enforcement purposes, FISA tends to require that the federal government must first get an order from the Foreign Intelligence Surveillance Court. How does the federal government obtain such an order? Well, it must demonstrate probable cause that the target of the electronic surveillance is a foreign power or an agent thereof. Next, the federal government must also show that each of the facilities or places being surveilled is also being utilized or is about to be utilized by a foreign power or its agent. The federal government is also required to establish that the minimization procedures it will deploy are reasonably designed to minimize the acquisition, retention, and dissemination of non-public information concerning United States persons. One must absolutely be mindful that FISA imposes serious criminal penalties on anyone who intentionally engages in unauthorized electronic surveillance under color of law, or who intentionally discloses or uses information obtained under color of law by unauthorized electronic surveillance, by knowing or having reason to know that this information was obtained through unauthorized means of electronic surveillance. In addition, FISA authorizes a private right of action for damages to any aggrieved person apart from a foreign power or its agent, anyone, that is, subjected to electronic surveillance or about whom information obtained by such surveillance has been unlawfully disclosed or utilized. FISA regulates the government's use of information that is obtained or derived from electronic surveillance conducted under that particular statute. As most pertinent here, perhaps, any person subject to surveillance pursuant to FISA has to be given, must be given, should be given notice and an opportunity to be heard prior to information obtained or derived from that surveillance being used in any court or agency proceeding against that person. Section 1806C of FISA says, whenever the government intends to enter into evidence or otherwise use or disclose in any proceeding against an aggrieved person any information obtained or derived from an electronic surveillance of that aggrieved person pursuant to FISA, the federal government is required to notify the aggrieved person and the court that it intends to so disclose or so use such information. Notably, Section 1806D, for its part, obligates states and their political subdivisions to do the same thing. Next, Section 1806E of FISA authorizes an aggrieved person against whom such evidence is to be or has been introduced or otherwise used or disclosed to move or suppress the evidence on the ground that 1. The information was unlawfully acquired, or 2. The surveillance was not made in conformity with an order of authorization or approval, either ground. Coming full circle, Section 1806F sets forth a structural mechanism to resolve in camera and ex parte questions of admissibility of such evidence so long as the Attorney General files an affidavit under oath that disclosure or an adversary hearing would harm the national security of the United States. That's language from the statute itself. Specifically, Section 1806F authorizes the Attorney General of the United States to invoke the in camera and ex parte procedures whenever a court or other authority is notified pursuant to subsection C or D, or whenever a motion is made pursuant to subsection E, or whenever any motion or request is made by an aggrieved person pursuant to any other statute or rule of the United States or any state before any court or other authority of the United States or any state to discover or obtain applications or orders or other materials relating to electronic surveillance or to discover, obtain, or suppress evidence or information obtained or derived from electronic surveillance under FISA. When the Attorney General of the United States invokes this section, that is, Section 1806F, the District Court is tasked with reviewing in camera and ex parte the FISA application, order, or such other materials relating to the surveillance as may be necessary to determine whether the surveillance of the aggrieved person was lawfully authorized and conducted. Section 1806F says that this review will be ex parte unless the disclosing of the pertinent content to the aggrieved person is necessary to make an accurate determination of the legality of the surveillance. If that happens, should that happen, then the district court may disclose to the aggrieved person, under appropriate security procedures and protective orders, portions of the application, order, or other materials relating to the surveillance. Now, should the district court determine, pursuant to Section 1806F, that the surveillance somehow was not lawfully authorized or conducted, then it would be becoming of that court to, and the court shall, under such circumstances, in accordance with the requirements of law, suppress the evidence which was unlawfully obtained or derived from electronic surveillance of the aggrieved person, or otherwise grant the motion of the aggrieved person. If, on the other hand, the district court determines that the surveillance was lawfully authorized and conducted, then it shall deny the motion, except to the extent that due process requires discovery or disclosure. That is the sum and substance of the dictate of Section 1806F. Now we must discuss the common law state secrets privilege. We come to that discussion. The executive's power and responsibility to safeguard the national security of the United States and to protect state secrets from exposure in litigation have been undisputed since the very beginning of our republic, from the moment that the ink was dry on our Constitution. As Justice Thomas has mentioned, the executive's duty to protect our national security is beyond cavil. As the court itself has mentioned, the executive's duty to secure the preservation of the republic is undisputed. And as the principal Ninth Circuit dissenter in this case, Judge Patrick Bumate, has mentioned, and we will talk about the Judge Bumate dissent, as he has mentioned, from the earliest days of our nation's history, all three branches of the federal government, have recognized that the executive has authority to prevent the disclosure of information that would jeopardize national security, embodied in the state secrets privilege. Such discretion lies at the core of the executive power and the president's authority as commander-in-chief. Indeed, these powers, Judge Bumate noted, were vested in a single person precisely so that the executive could act with the requisite decision, activity, secrecy, and dispatch. That's from Federalist number 70 by Hamilton. In a nutshell, that's the common law state secrets privilege. It has serious constitutional moorings. Supreme Court has recognized those moorings. Going as far back as Totten versus United States, that's in 1876, the Supreme Court held that as a general principle, public policy forbids the maintenance of any suit in a court of justice, the trial of which would inevitably lead to the disclosure of matters which the law itself regards as confidential, such as state and military secrets. A likely basis for such a rule would be the Executive Power Clause, the Executive Vesting Clause, in Article 2, Section 1, Clause 1 of our Constitution, and in Nagel, which the Supreme Court decided in 1890, established that the President has even a take-care clause obligation under Article 2, Section 3 of our Constitution, that's also a constitutional duty of the President's, to ensure that the federal government's core functions can operate by, for instance, and this is just an example, non-exhaustive, protecting the personnel who discharge the various roles under our Constitution and enforce our laws. Under In Re Nagel, then, the Take Care Clause enables the President to do what he deems appropriate to execute a command that is statutory and/or is treaty-based, or one that grows out of, in the words of Nagel, the rights, duties, and obligations growing out of the Constitution itself, our international relations, and all the protection implied by the nature of the government under the Constitution. Not too long ago, just about a decade ago, in a case called General Dynamics Corporation versus United States, the Supreme Court observed that it had long recognized the sometimes compelling necessity of governmental secrecy by acknowledging a government privilege, as the General Dynamics Court called it, against court-ordered disclosure of state and military secrets. And as mentioned earlier, the common law state secrets privilege has its basis in both the law of evidence, that's a language in the Supreme Court's 1953 decision called U.S. versus Reynolds, as well as the executive's Article 2 obligation to protect sensitive military or diplomatic secrets. Even if a litigant were to make a strong showing of necessity for discovery or use of information, the state secrets privilege applies whenever there's a reasonable danger that compulsion of the evidence will expose military or other matters which, in the interest of national security, ought not to be divulged. That's pretty much taken verbatim from the Reynolds opinion of the Supreme Court in 1953. Reynolds made it crystal clear that the privilege can at times even be absolute. Even the most compelling necessity cannot overcome the claim of privilege if the court is ultimately satisfied that state secrets are at stake. How does the federal government invoke the state secrets privilege? Supreme Court precedent, namely Reynolds, provides a roadmap. There must be a formal claim of privilege lodged by the head of the department which has control over the matter after actual personal consideration by that officer. The head of the agency, the department, must have weighed in by giving it actual personal consideration under Reynolds. Once a formal claim is lodged, the court itself must determine whether the circumstances are appropriate for the claim of privilege without forcing a disclosure of the very thing the privilege is designed to protect. Otherwise, it would just be circular and wouldn't make much sense, would it? Should the court accept the federal government state secrets privilege claim, then the privileged information is completely removed. General Dynamics called it the privileged information is excluded, should be excluded. And when the privilege is invoked by the head of the department, the case may proceed without the state secrets. That's also been a well-established rule. Now, the Ninth Circuit said in a 2010 en banc opinion that the assertion of the state secrets privilege will require dismissal where litigating the case to a judgment on the merits would present an unacceptable risk of disclosing state secrets. That's from a case called Muhammad versus Jefferson Data Plan. And neither party can obtain, may obtain, should obtain judicial relief where the privilege precludes adjudication on the merits. Now, what happened in this case? Plaintiffs, respondents here, are Muslim individuals who live in Southern California. They brought this putative class action in 2011 against the United States, the FBI, and several FBI officials and agents in their official and individual capacities, respectively. The factual nucleus of the case is plaintiff's allegation that between 2006 and 2007, the FBI deployed a confidential informant, a gentleman by the name of Craig Montea, to covertly gather information about Muslims in their Southern California communities, and that the FBI did so on the basis of religion. Respondents also allege that the FBI had this informant investigate, through non-electronic and electronic surveillance alike, activities in these Muslim communities. Plaintiffs further allege that the informant, Mr. Montea, gathered personal details like email addresses, phone numbers of various people by engaging in in-person interactions with them. Plaintiffs also allege that this informant made video recordings and audio recordings of homes, mosques, businesses, events, conversations, lectures, so on and so forth. And plaintiffs allege that the FBI planted bugs in one plaintiff's home and in another plaintiff's workplace. The plaintiffs asserted Establishment Clause, Free Exercise Clause, Fourth Amendment, Equal Protection component of the Due Process Clause, the Federal Tort Claims Act, Section 1810 of FISA, the Religious Freedom Restoration Act of 1993, RFRA, Privacy Act, and also California state law. Plaintiffs want damages from the FBI agents under the 1971 case, the famous case of Bivens versus 6 unknown named agents of the Federal Bureau of Narcotics, as well as Section 1810 of FISA. They want damages from the government of the United States under the FTCA and California state law, and they want an injunction compelling the government of the United States to destroy or return any information gathered via or somehow derived from unlawful surveillance. Now, at this stage, the United States government, through an assertion of the Attorney General, formally invoked the state secrets privilege through an affidavit by the AG regarding and over information concerning whether any particular individual, including each of the respondents, was the subject of an FBI counterterrorism investigation, the reasons for any such investigation, and the particular sources and methods that were used, including, of course, any undisclosed electronic surveillance. The federal government submitted to the district court various classified declarations so articulating and saying that this information could and might harm the national security of the United States. Then the district court upheld the federal government's claim of state secrets privilege. It dismissed plaintiffs' claims against the United States as well as against the official capacity government defendants. The district court found that disclosure of the privileged evidence would significantly compromise national security. That's a direct quote. The district court also determined that litigation of this action would certainly require, or at the very least greatly risk, disclosure of secret information, such that dismissal at this stage of the proceeding is required, is desirable. But the U.S. Court of Appeals for the Ninth Circuit had something else in store. That court, a 3-judge panel thereof, reversed this determination by the district court. The Ninth Circuit panel held that the procedures established under FISA for adjudicating the legality of challenged electronic surveillance they supplant, the Ninth Circuit said, the common law state secrets privilege regarding such surveillance to the extent that this privilege allows the categorical dismissal of causes of action. The 3-judge panel of the Ninth Circuit further held that the district court was wrong to dismiss plaintiffs' claims. The Ninth Circuit thought that it should base its decision on Section 1806 of FISA in order to decide plaintiffs' claims. Why did the Ninth Circuit think that 1806F was in play here? As an initial matter, the 3-judge panel interpreted the governmental declaration by the AG invoking the state secrets privilege to exclude certain information as constituting notice. They thought it was notice under Section 1806C of FISA of the government's intent, notice of the government's intent to use or disclose information obtained or derived from electronic surveillance against plaintiffs' claims, as the government would represent later on to the Supreme Court in its cert petition. Next, the Ninth Circuit panel deduced that a prayer for relief in plaintiff's complaint counted as a motion or request to discover, obtain, or suppress evidence or information obtained or derived from electronic surveillance under the text of FISA. The Ninth Circuit proceeded to conclude that it displaces the common law dismissal remedy created by the Reynolds opinion of the Supreme Court in the 1950s and 53, the Reynolds opinion's state secrets privilege as applied to electronic surveillance under FISA's purview. And as far as the Ninth Circuit panel was concerned, FISA's text and legislative history showed that Section 1806F's in-camera and ex parte procedure were the exclusive procedure for evaluating evidence that threatens national security in the context of electronic surveillance-related determinations. The 3-judge panel reversed the district court's dismissal of plaintiffs' claims on the basis of the common law state secrets privilege. The Ninth Circuit panel then remanded the case for further proceedings back to the district court. The Ninth Circuit panel directed the district court to use Section 1806F's ex parte and in-camera procedures, review any materials relating to the surveillance as may be necessary, including the evidence over which the Attorney General asserted the state secrets privilege, to determine whether the electronic surveillance was in fact lawfully authorized and conducted. The Ninth Circuit panel also instructed the district court, in its words, as permitted by Congress in making this determination, the district court may disclose to plaintiffs portions of the application, order, or other materials relating to the surveillance if that is necessary to make an accurate determination. The Ninth Circuit panel further held that the district court may rely on its assessment of this evidence to determine the lawfulness of the surveillance falling outside FISA's purview. The Ninth Circuit deduced that it would stretch the privilege beyond its purpose to require the district court to consider the state secret's evidence in camera and ex parte for one claim, but then, when considering another claim, ignore the evidence and dismiss the claim. The Ninth Circuit argued that should its prediction of the overlap between the information to be reviewed to determine the validity of FISA-covered electronic surveillance and the information pertinent to other aspects of plaintiff's claims proves to be wrong, then the government of the United States could interpose a specifically tailored, properly raised state secrets privilege defense. A badly fractured full Ninth Circuit Court of Appeals denied rehearing en banc. From the original panel, Judges Gould and Berzon filed a separate opinion concurring in that denial of rehearing en banc. They were joined by Judges Wardlaw, Fletcher, and Paez. That concurrence basically reprised the arguments from the three-judge panel opinion, as did a statement issued by the visiting judge, Judge Stee, senior U.S. District Judge for the Eastern District of Michigan, who had been sitting by designation on the original three-judge panel. Judge Bumate, joined by 9 other Ninth Circuit judges, dissented from the denial of rehearing en banc. Judge Bumate noted, as I've mentioned earlier, that the executive's power to prevent the disclosure of information that would jeopardize national security has been well established since the earliest days of our nation's history. It's been there since the beginning. Judge Bumate also observed that this authority exists at the core, at the heart, at the very nucleus of the executive power that Article 2 vests in the president. It is also found, Judge Bumate contended, in the president's authority as commander-in-chief. Judge Bumate further pointed out that when federal courts, a coordinate branch of the U.S. government that the framers designed to give neither sword nor purse, neither force nor will, but merely judgment, that's from Hamilton in Federalist 78, confront a legislative enactment implicating such constitutional concerns, that's from Bumate, it has commonly required a clear statement from Congress before plowing ahead out of a due respect for those constitutional concerns. In Judge Bumate's words, I continue, Section 1806F falls pitifully short of that constitutional standard. The constitutional backdrop against which all of this was operating, as alluded to by Judge Bumate and other legal thinkers, is that the federal courts should be very careful, very, very cautious and hesitant about invading the preserve of its coordinate branches, especially the executive on national security. Because not only do federal courts have no competence or knowledge about such matters, they, most importantly, just are not the branch to which the Constitution commits this issue. As already noted, the secrecy, dispatch, and the other things that permit the executive to act as a singular person, a singular unit, do not pertain to the courts. The courts just do not have the expertise, the knowledge, the know-how, the subject matter awareness of these issues, nor are they structurally set up to be responsible to the people for knowing those things or to be punished if something goes wrong. Accountability is non-existent or certainly much less, categorically less existent than it is for the executive. There's a deontological basis for this principle and a deontological derivation. The bargain that Alexander Hamilton and the framers made with the people of New York, to whom Federalist 78 was addressed, and therefore with the people of these United States, was that yes, let's give the federal judges life tenure and job security as well as salary protection, not to mention the authority to say what the law is, as Marbury says. But in exchange, the federal courts will be mindful, will be careful, will be hesitant, will be cautious about coloring within their own lines and staying in their own lanes, and they will never veer off to the lanes of the states, Congress, the president, private entities, or any other actors. When that bargained for exchange, the terms of that deal are cavalierly breached, then the entire structural integrity of the federal judiciary is called into grave question. Serious doubt about the separation of powers itself ensues. It cannot be far behind. And returning to the precise issue addressed by Judge Bumate's dissent, there was more. Historical practice and background, of course. In Justice Scalia's eminent words in a concurring opinion that he issued in a case called NLRB versus Noel Canning, a very famous case from 2014, Justice Scalia said, "A governmental practice that has been open, widespread, and unchallenged since the early days of the Republic, like the state secrets privilege, merits special deference and special consideration as a historical background, and congressional action to the contrary must be clear in order for it to be effective and for it to be effectuated." A snippet of that historical practice was well framed by Judge Bumate's dissent. He said, in 1792, when President George Washington found himself faced with the first ever congressional request for presidential materials, he recognized an executive privilege to avoid disclosure of secret material. Washington's cabinet, which included Alexander Hamilton and Thomas Jefferson, agreed that the executive ought to communicate such papers as the public good would permit, and ought to refuse those, the disclosure of which would injure the public. The state secrets privilege is believed to be a branch, actually, of executive privilege. The Ninth Circuit panel, Judge Bumate feared, had devised its rule out of implications and inferences at best, as the panel saw them, not from a clear congressional authorization. A clear statement from Congress was required. Much more than what was actually available was required for Congress to create a serious constitutional question about the validity of that application of FISA, or when the court is interpreting a statutory provision against that historical and constitutional backdrop. There's nothing new about this. These are time-honored, well-known, and conventional canons of statutory interpretation. Judges have been mentioning and applying them for years now, for centuries now, and they're ensconced also, collated, collected, elaborated upon, and articulated in Justice Scalia's magnum opus on statutory interpretation, reading law, the interpretation of legal texts. The reason for this, the raison d'etre for this rule, for this canon of interpretation, isn't just that courts should avoid a constitutional clash or incompatibility between statute and constitution or supreme law, though that is part of the reason, but also that Congress is presumably not legislating in a way that ignores the elephant in the room, devising an interpretation that acts in disharmony with the historical background, presumption, constitutional backdrop, historical backdrop, and the like. Just as again in Justice Scalia's words, Congress is not hiding elephants in mouse holes. Congress is not ignoring historical practices either. And if Congress is doing so, then Congress, at the very least, must speak clearly. Otherwise, courts should not impute that awkward interpretation to Congress. It would be a kind of anomalous approach for courts to undertake. Here, the potential for constitutional clash, tension, incompatibility, anomaly, and so on is profoundly heightened by, as Judge Bumate noted, as noted earlier, the national security nature of the state secrets privilege. National security is committed to the executive, not the courts primarily. It obviously goes to the heart of the president's authority to keep our nation safe. And keeping the community safe is, deontologically speaking, at the heart of the Lockean sovereign's duty, the indispensable pillar of that Article 2 responsibility inherited by our own chief executive. Now, we all know that John Locke, as Justice Gorsuch's dissent in Gundy pointed out, and as other jurists and legal thinkers over the years have also pointed out, was by and large the Enlightenment thinker whom our framers had in mind when devising our own constitution. And the Lockean sovereign that that was designed is in keeping with the principles of our chief executive, our Article 2 powers conferred on our president. The framers of our constitution thought, particularly when they were designing Article 2, thought this national security obligation of an American president so central to the presidency as an institution, so peculiar to the presidency as an institution, so exclusive to the presidency as an institution, to keep at bay the interloping by other actors, including the Hill, Congress. So that made, in Judge Bumate's view, the Ninth Circuit panel's determination all the more bewildering and indefensible. This is a worthy and apt issue to explore in some detail rather than just en passant, in passing. The framing generation was most clear that the president's internal executive power, part of his executive vesting clause authority, is to be employed in the peace, security, and protection of the subject and his property. That's from Essex Result, the popular sources of political authority, documents on the Massachusetts Constitution of 1780. Justice Thomas pointed that out in his Zivotofsky separate opinion in 2015. The framing generation feared that the execution of the municipal laws of society would fall apart if national security were undermined or if lawlessness derived from national security chaos became a menace. And that's part of it. Part of that quote is directly from Locke. Another thing from Locke is that that particular phenomenon that I just outlined, the framers of our Constitution feared, and the framing generation feared, the living community at the time, they feared, would become a prescription for disorder and ruin. Disorder and ruin, that's from Locke again. The executive vesting clause in Article 2, Section 1, Clause 1, as I've mentioned, incorporating the Lockean sovereign's core duty of preserving the national security as well as the territorial, maritime, aerial, and other integrity and sovereignty of the United States, thus empowers the presidency in some major ways. That is the conventional constitutional thought. To be sure, this viewpoint acknowledges the president's power to protect national security, and many scholars think, many thinkers believe, it will not give him any refuge if he manifestly is harming or risking national security. It thoughtfully can be argued, therefore, that neither Congress nor the courts may second-guess whether the president's actions were congruent and proportional to the threat, because he can act even preemptively so long as he reasonably and in good faith promotes national security. This means that congressional encroachments on this relatively undiluted presidential preserve will violate the executive vesting clause and separation of powers and so on and so forth, as many legal thinkers have believed over the years. Much like the president's external executive power running foreign affairs, in which the president also has supremacy under the residual executive power derived from the executive vesting clause, the internal executive power is subject to being controlled by the legislative branch only through congressional appropriations, Senate confirmations, and other specified carve-outs given to Congress by our Constitution. Some of that language is from Thomas Rutherford's Institutes of Natural Law from 1754. Without the carve-outs, sans the carve-outs, the president retains what scholars have regarded as the residual executive power, and that permits the president to govern the sphere of national security and other related issues pertaining to national security. What is interesting is that Judge Bumate rightly critiqued and criticized the Ninth Circuit panel for overlooking the fact that, in his words, Congress articulated no directive in FISA to displace the state secrets privilege, even under the most generous abrogation standards. Most fundamentally, the court should have ensured that Congress was unmistakably clear before vitiating a core constitutional privilege. When the Supreme Court confronts a legislative enactment implicating constitutional concerns, federalism or separation of powers, for instance, it has commonly required a clear statement from Congress before plowing ahead. It has done so out of a due respect for those constitutional concerns. The state secrets privilege is no different. It deserves the same respect. I improvised a little bit, but most of that is from Judge Bumate's dissent. Judge Bumate went on to explain that Section 1806F of FISA simply doesn't apply in these circumstances, and it fails to displace and supplant the common law state secrets privilege. That privilege is as applicable to a case like Fazaga as it is to all other cases and situations in this overall space, he maintained. Actually, under Judge Bumate's view, Section 1806F argued, the 10 dissenters on the Court of Appeals, including Judge Bumate, of course, they argued that 1806F provides procedures to determine the admissibility of electronic surveillance evidence when the government tries to use that evidence against someone in court. The dissent further argued that the federal government's invocation of the privilege through the declaration, the affidavit by the Attorney General to remove evidence from the case, just did not bring into play Section 1806F's procedures. And why? Because it didn't provide notice of any governmental intent to use that evidence against plaintiffs. And in this very case, plaintiffs' request to destroy or return any information obtained or derived from government surveillance just didn't qualify as a motion or request to discover, obtain, or suppress evidence or information. And that's, language from FISA, of course, that would activate, bring into play Section 1806F. Judge Bumate articulated that this diction, to discover, obtain, or suppress evidence or information. This language refers exclusively to motions to suppress or that kind of procedural moves. It doesn't apply, Judge Bumate pointed out, to substantive requests for relief, as he called it. On December 19th, 2020, the then acting Solicitor General of the United States petitioned the Supreme Court for a writ of certiorari, asking the court to take this case, to resolve this issue. And on June 7th of 2021, the Supreme Court granted that petition, and in the following August, the court set the case for oral argument. Arguments, as I mentioned earlier, were heard in November, and a decision is expected by June of 2022. The Ninth Circuit's rule is broad enough to engender significant discomfort among the justices, and whatever the court does in this particular case, it is likely that the court will not let the Ninth Circuit's sweeping rule stand intact and undisturbed.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.